The distinction between natural versus conventional rights and laws needs to be understood because this is a fundamental question in the whole philosophy of law, the nature of law, and is often an issue when different legal systems come into some kind of conflict. Natural rights come from the way the universe exists, the way humans exist, the way the land exists, and the natural relationships between the parts, mainly between humans, and sometimes when those relationships between humans are mediated by their interest in land. Natural laws come from the nature of existence. People cannot change them, they can only find them. And the reason for this is that they are a part of nature, in the same way that when we talk about nature, commonly we're thinking about forests and trees and wild animals and so on. It's the way things are even when people aren't about. And there's only a limited amount that people can change things. We have to work within our nature, within the nature of existence. If we find a forest, we can either chop it down or we can leave it in its existing form. We can't make a plastic forest. By contrast, often in human affairs, we make arbitrary rules, convenient rules, then we simply put forth a rule and everyone accepts it. We use the word positive. Now, we're not using it in the same sense as an electrician might, or a mechanic when they look at the car battery and say there's positive and negative. It's coming from the notion that the word to posit simply means to put. Anyone who has had a baby to look after knows all about what posits are. They are things which are put often in inconvenient places. Hence it gives rise to the understanding of something having a position. Position comes from the word positive, from the word to posit. And so positive refers here to something that is arbitrarily put in place. A bit like arbitrarily setting up the rules for a particular card game. Got the same 52 cards. I can play 500 or poker with the same cards, but it's a set of arbitrary rules that are put in place that people then enjoy their card game. Positive laws are arbitrary laws. They're conventions. They're agreed sets of rules without anything really behind them. They are made by illicit authority, such as the government, for the better ordering of society. Sometimes they might be put together by the bridge club or the football club deciding whether they're going to play AFL or rugby. An example of a positive law is driving on the left-hand side of the road in Australia. One of the important things about positive laws is that they can change, and they often do. We've seen the ways that games, basketball, football, so on, have changed over time. They've developed because they're not grounded in something fundamental. They are simply the doings of a collection of humans in some social situation. Let's look at conventional property in land. Our title systems are like this. They're arbitrary. They're positive laws. We don't have to have Torrens titles. We don't have to have old systems. We could have a feudal system. We could have a customary title system. We have a number of title systems. We in Australia use the Torrens system, and in some cases old system titles, if it still exists. It's largely being written out of the equation, and it's dependent on the social order. Our conventional properties in property and land, our title systems, establish bundles of rights for use. This is because you can't actually own something that you haven't made or isn't fundamentally a part of you. You may possess rights to use it in the sense that a right is an obligation on everybody apart from the right holder to allow that person to do certain things or not do certain things. And rights in a material sense are established and overseen, protected by the force of the government. Each right relates in some manner of using the land. And when we break up property rights, looking at things like mining rights, easements and so on, we see that it's really different aspects of the way that humans desire to use the land, either to simply walk across or to dig holes in or to grow sheep on, whatever. The establishment of our property rights system is established to respect human natural rights. And as we saw in one of our first slides, these are principally right to life, right to the various other properties of life, and hence also our labour. Hugo Grotius, we noticed, looked at the need for personal space, and that's a natural human right, to deprive a human of personal space, any human personal space, and it's going to be very hard for them to live, and life is their natural property. And it's also needed in order to protect the personal labour invested in land. So while they are arbitrary positive laws, they have this object in it which is natural, and it has to do ultimately with the rights of the human person. Positive, that is conventional laws, are tested against justice, and so we have to have an understanding of justice. So what we'll need to do is explore the notion of justice and the notion of these positive and natural laws and how they interact and how we can find them, because that helps us to understand how to change them. If we're looking for justice, we will have to start with a definition. And in fact, we're going to be going through a number of definitions, because once you have your definitions clear and understood, it makes it very difficult to move forward with reasoned arguments. The definition of justice, the classical definition of justice, is to give each his due. The natural properties infer obligations in justice. This means that if I have a right to life, that's my due. And so justice must protect my right to my life against other people who may want to take it, either in whole or in part. We can say that taking the life of an innocent person, we call that murder, is naturally unjust. Why is that? Because if the person is innocent, it's not as though they've come to rob your house or kill you or take your country. If we're talking about a war, then there is going to be an injustice done if I simply decide to take your life. It's not something which we've simply decided as a community, although it's handy if we do. Rather, it's built into the very nature of what it is to be human. Similarly, slavery is unjust. We live in an odd period of history where slavery is generally prohibited in most developed countries, at least to some extent. There have been periods in time, in fact, great civilizations, where slavery was permitted. Was slavery just because the Roman law permitted it? Or was it naturally unjust and the Roman laws were bad laws? It's a useful question to consider, especially because if it was simply a matter of what the law of the land is at a particular time in history, maybe next year with a change of government or next so many years, we might find ourselves in Australia permitting slavery. We may buy part of another person's life usually in exchange for an equal part of the life of oneself. That is really a complicated description of what commerce is. Economics is largely reducible to an exchange of labour, a very complex exchange of labour, where we use the medium of money and we want some sense of justice. We rely on our economic theories to supply that notion of justice. But it all ultimately comes down to exchanges of people's life denominated in time, which we've spoken about before. If justice is coming from nature, the nature of the human person and so on, it means that justice is found. It's not invented. And we'll talk about this further in subsequent slides. If it's found, it means it's not a feeling. We might have a sense of justice, but ultimately it's not a feeling. Now, this has been controversial in different times. The 18th century British philosopher David Hume believed that we had a sense of justice. To a certain extent, that's true. We do have a feeling when we see some violence being done, especially when some bully is pushing around a small child, or some country is being invaded unnecessarily, or genocide and those sort of things. We certainly recoil in abhorrence from being presented with those things. But the feeling is merely a hint of a reality. It's the same way that we have a feeling that something is wrong when we have a brick on our toe. Objectively, there is a brick on our toe. Subjectively, we have the feeling that it's very uncomfortable and we want to do something about it. But ultimately, that feeling, while it's very handy for protecting your toes, is actually a discovery. The brick is really there. If we look down and we feel like we've got a brick on our toe, but we really haven't, we would say there's something wrong with our nervous system. We can understand justice as a moral concept. To probe that, we have to understand what morals are. We often confuse the two words morals and ethics in our present society and conversations. It's useful to untangle those because it's very helpful when we're understanding the law. A moral is a principle for the appropriate relationships between intelligent beings. Appropriate behaviour between intelligent beings could also be used there as the definition. So if I'm doing something which is immoral, it means that it's inappropriate. We haven't worked out what appropriate might mean, but from our previous discussion, the idea of doing something which is outside nature, like killing somebody, we can say is immoral. Similarly, to differentiate that from an ethic, properly speaking, is a set of morals. Usually it's a collection of moral principles pertaining to a particular situation. And so there will be professional ethics for financial planners, particular ethic, which might be slightly different for property economists. Property economists, say operating as valuers, will find that there are certain principles they have to adhere to, largely to do with understanding and managing the notions of the property rights involved and their values and so on, that perhaps a financial planner may not be so interested in. And so the financial planning ethic does not necessarily correspond exactly with the property economist's ethic. The financial planner might be more interested in the rules relating to superannuation and not having some kind of a kickback from some insurance company or whatever it is, as a key part of their ethic. A valuer doesn't have relationships with the insurance industry, and so it's not part of their professional ethic. And so these are ethics. We tend to use the expression fairly loosely today, often as virtually a synonym for moral. And so we'll talk about ethical people. We tend not to talk so much about moral people, although in fact the two ideas are intimately connected. We can say that justice is the measure of the appropriateness of some human relationship. The insertion of the notion of appropriateness into our understanding of justice hints at the fact that justice is in fact a moral concept, and you can even use justice as the measure of morality. If a moral is a principle for the appropriate relations between intelligent beings, then we can say that the measure of morality, or the effectiveness or the appropriateness even of a particular principle which might want to call a moral, is related intimately to its justice. High level of justice means that moral is reliable. Low level of justice would suggest that the moral is suspect. While we're discussing this connection with morality, it's useful to note that there are other moral words. Justice is certainly one of the core ones. It's one of the reasons why the word is so common within our legal system, even down to just terms of compensation written into the Australian Constitution. Other words which flag that we're talking morality, we're talking in terms of principles for the appropriate relations between people, are words like should, or must not, or should not. And we find that a very large part of human discussion actually hinges on words like this. Think about that when next you're having a coffee or a beer with some of your friends. You'll often hear people talk about he or she shouldn't do this or should do that, and so on. We live as humans in a moral environment, and to a certain extent, our ability to act socially, to survive in a social environment, relies on the shared moral system, the set of principles, the ethic, if you like, that we share with the other people who we deal with in our society. And those dealings change in intensity depending on the relationship in particular. When we're talking in these terms, it tends to infer a particular attitude to the theory of justice that's lurking in our understanding of the law. At this point, it's useful to consider the way that there are at least two competing theories of law. Laws, after all, are merely rules, sets of rules, maybe an ethic you could call them, but in fact they're not. They might be. They are sets of rules that attempt to enshrine justice in some practical way, and in some cases they are simply there for the better ordering of society. But largely, most laws, and most of the time when we think of law, we tend to think of rules that define justice and ensure justice, and anyone who is not acting justly we put in prison or fine them or something. When we go into the philosophy of law, the theories of law, there are two competing theories. One is that law comes from the nature of things. We call that natural law. And we've been talking about natural law a fair bit in this series. It assumes that we can know reality, or at least important parts of it, in order to be able to determine what are appropriate as those rules, those laws that we use to govern our society, or perhaps our football club. The alternate theory of the origin of law is that law merely comes from opinions. And that would suggest that all of our laws are no more than positive conventions that come from the opinions of important people, usually. And when we take the latter opinion, that all laws come from opinions, usually of those in positions of influence, we can ask, where do the opinions of the people making the positive laws come from? And we'll come back to that as we go along, because these two approaches are largely drawn from two competing theories of knowledge, or epistemologies. We have another definition. An epistemology is the study of how knowledge is obtained, and as well as that, the word is used to relate to a particular theory of how knowledge is obtained. So there are competing epistemologies, theories of how knowledge is obtained, and as a result of that, some learned people explore the question, they study the question of how knowledge is obtained. There are two basically positions which have a parallel to what we were saying above, that knowledge of reality is possible. In other words, knowledge of nature, of the nature of things is possible, or at least of some aspects of nature, even if it is sometimes difficult. The second position, or the second theory, is that knowledge of reality is impossible, which means we can only ever have an opinion about reality. We can never be sure. To resolve that question, it's also important to just be wary that position one, it does not infer that you have to have the knowledge of everything. Because obviously we don't do that and we can't do it. But only to be able to know with reliable certainty, tested certainty, the relevant things, some parts of nature. And this is important when people argue over these two positions, because often those who are of the opinion that we can only have opinions criticise the fact that we cannot know everything, and their conclusion from the fact, the uncontroversial fact that we can't know everything, that is taken to the conclusion that we can't know anything. And a little bit of reflection will resolve that for you.